Senator Dillon, and to Senator Escudero, whom I have jumped over in our queue because I am sick. Thank you very much for allowing me to speak earlier than scheduled. First of all, Mr. Chair, I would like to enter for the record only certain of my reservations and just general comments on constitutional law involved in this case. Oh, there you are. Let me take a good look at you. Kasi naging RTC judge kasi ako eh. Batang-bata lang ako. At ang unang tinuro sa amin ay, ang unang katungkulan ng isang hukom ay pag-aralan niya ang pagmumukha ng testigo. Observe the demeanor of the witness. Now that I observed your demeanor, I more or less know what things would make you quarrel with your husband. Mr. Chairman, I have certain reservations for the record. Number one, right against self-incrimination. The Philippine and U.S. constitutions have different versions, with the result that the right against self-incrimination is more lenient in our country. The U.S. Constitution Amendment 5 provides, quote, no person shall be compelled in any criminal case to be a witness against himself. Notice that in the United States, and therefore in American jurisprudence, picked up sometimes by our Supreme Court, the right against self-incrimination applies only in a criminal case. This is not a criminal case, this is an administrative case. Therefore, ordinarily, if we were in America, there would be no right against self-incrimination. But it's not the time to examine this constitutional concept. By comparison, the Philippine Constitution in the Bill of Rights, which you know as Article 3, Section 17 provides, quote, no person shall be compelled to be a witness against himself without any qualification. Kaya, mas malawak ang right against self-incrimination ni Mrs. Napoles na akusado. Sa Pilipinas, nasa Amerika, maswerte ka, hindi ka binista sa Amerika. In addition, the Philippine Constitution provides in Article 6 concerning the Legislative Department, Section 21, referring to inquiries in aid of legislation, quote, the right of persons appearing in or affected by such inquiries shall be respected. Constitutional right na igagalang kita bilang akusado. I will not bully you. I will not attempt to outshout you. So I hope you'll show me the same courtesy by telling the truth, the whole truth, and nothing but the truth. I remind you, Mrs. Witness, pwede ka magtanggi sa pagsagot ng maski anong tanong na makababaon sa iyo o makasangkot sa iyo sa isang krimen. Karapatan mo yan. Pero wala kang karapatan magsabi ng sinungaling. Pag nagsinungaling ka, lagot ka. Kaya kaiba yung ayaw kong magsagot dahil baka lalo akong mabaon dyan sa krimen na yan. At iba rin yung magsinungaling ka sa harap ng isang senador. Nagsusumpa ka eh. The Supreme Court has ruled, quote, the right of the accused against self-incrimination is extended to respondent in administrative investigation. This is an administrative... What is so funny over there? I've just finished talking about respect for me as for my other senators. This is an institutional hearing.
I'm sorry.
You should be. The right of the accused against self-incrimination is extended to respondent in administrative investigations that partake of the nature of or are analogous to criminal proceedings. This is the latest case, Standard Chartered Bank versus Senate Committee on Banks, 2007. Kaya, walang duda na may right ka against self-incrimination maski hindi ito criminal case. This right may be invoked by resource persons only when the incriminating question is being asked. The consolation is that when this right is abused, such issue may be presented before the court. Kung ayaw mo ng ruling namin, mamaya pag sinabi mong ayaw ko magsagot dahil baka masangkot ako. At sa tingin ko, hindi ka masasangkot ng pagtatanong ko. At sabihin mong ayaw ko, mag-aapila ako sa chair ng committee. O kaya magre-recess kami. Pero hindi ikaw ang magdedesisyon. Kung masasangkot ka, hindi. Kami. At kung hindi ka kontento sa ginagawa namin, pwede kang pumunta sa korte. Korte de Justicia. The question whether testimony is privileged is determined by the court. Nang wala ko dito, sari-saring insultong inabot ko. Dahil yung tao na kasapi ng Senado, hindi man lang college graduate, hindi abogado, kailanman hindi na practice kung ano nung pinagsasabi na may kapangyarihan itong Senate Committee na magbigay ng immunity. Mali! 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 Tapos akong insultuhin niya. Sistema ang pinag-usapan natin, mang-insulto personal kagad para masaktan ako. Ano klaseng assembly ito? Now we are bound by the canons of civility and decency. The first rule in debate 101 is stick to the principles involved. Stick to the issues. Do not go into personalities. Kagad ang sagot niya sa akin ay tungkol sa personalidad ko. The question whether testimony is privileged is determined by the court. At least it is not enough for the witness to say that the answer will incriminate him as he is not the sole judge of his liability. Arnold versus Nazareno, 1950. That is my first reservation about the right against self-incrimination. The second reservation, the meaning of self-incrimination. Hindi naman pwede, Mrs. Napoles, na lahat na lang tatanggihan mo at sabihin mo, baka masangkot ako. May mga regulasyon yun eh. To apply the privilege against self-incrimination, this is the standard, the test, the guideline. We ask whether the claimant is confronted by substantial and real, and not merely trifling or imaginary hazards of incrimination. Kailangan totoong masasangkot nga siya. Hindi na tatakutin lang tayo na lahat yan masasangkot mo. Whether the accused to most guilty is highly factual in nature. And, let me give you an example. Said the court, we cannot compel the witness or accused to furnish the specimen of her handwriting on the ground that writing is not a purely mechanical act because it requires the application of intelligence and attention. Marcelo V. Sandiganbay, 1999. Kaya, hindi lang namin napilit sa iyo ay yung kailangan gamitin mo ang utak mo, ang pag-iisip mo. Yan, protektado ka dyan ng batas. Pero kung halimbawa, sabihin namin, dalhin mo dito ang isang ebidensya, dadalhin mo yan. Dahil kailangan na gamitin mo ang utak mo, ang pag-iisip mo. And, last, reservation. You may have no right to public attorney. Who is the public attorney here? I am not entirely sure that under the Constitution, the accused Mrs. Napoles has a right to counsel. The Constitution in the Bill of Rights, Article 3, Section 12, Paragraph 1, protects any person under investigation for the commission of an offense. That's actually custodial investigation when there's a crime committed and the police pick up a suspect. Our Constitution provides that, quote, if the person cannot afford the services of counsel, he must be provided with one. But, Mrs. Napoles, from what we've heard about you in the media, you can certainly afford the services of counsel. You yourself have chosen not to be accompanied by counsel. Ikaw namili eh. Ayaw mo. Only 3 days ago, your counsel in the Plunder case resigned and you knew you would not have a lawyer today. You have another counsel for the case of serious illegal detention, but you refused to bring him here. Kaya kagustuhan mo na lang talaga na wala kang abogado para magamit mong rason na naghahanap ka pa. At hindi dapat nabigyan ka namin ng libre na galing sa public attorney's office. Dahil sa batas, yung public attorney's office ay para lang sa mga mahirap na hindi makabayad ng abogado kasi mahal ang abogado eh. So I have my reservations. Ngayon, pagtatanong. When Mr. Ben-Hur Luy testified here in the Senate, he identified 3 senators as tanda, sexy, pogi. Question, isang to rin